Hello, I'm Nick Hobden, partner and head of the employment team here at Thompson, Sell and Passmore. And today I'm joined by Jessica Wells, a solicitor in the team. And we're here to talk about issues to do with employees of private wealth estates. And specifically, what happens at various stages of the employment relationship. So we're going to talk about, for example, what happens when the employer who employs the domestic employee dies, what happens with who takes over as executor, what happens in relation to service occupancies, because frequently employees of private wealth estates live in accommodation provided by the employer. So Jessica, I've mentioned service occupancy. Can you tell me exactly what a service occupancy is?
So a service occupancy is a type of agreement between employer and employee whereby the employer wants or requires the employee to live on site either for the better performance of their duties or to carry out their duties. And it's slightly different to a normal tenancy arrangement where an employee or an individual would be paying rent, in that it creates a license to occupy as opposed to creating those tenancy rights. So it's really important when you have an employee who needs to live on site or supposedly should live on site to carry out their duties, because for an employer, at the end of their employment, at the end of the employee's employment, they will want to make sure that they leave that property. Normal tenancy rights, it makes it a lot harder. A service occupancy makes it easier, because when the employment ends, the service occupancy ends, the employee needs to leave that property. Now, you can't just give a service occupancy out left, right and centre. There are strict things that an employee has to follow. So firstly, either it has to be a necessity that the employee stays in that property to carry out their duties. Yeah. So that could be a housekeeper, a carer, someone like that, or it has to be identified in the contract that it's for the better performance of their duties. So they don't necessarily have to stay in the property, but the contract outlines that they should stay in the property.
And this is the contract of employment
It is, yes. About. Yes, it is, okay. Yeah. So when it comes to the contract and the service occupancy, there has to be a link between the two. So we would, when drafting these agreements, the contract has to refer to the service occupancy has to refer to the contract. Even better if they're included within the same document.
Thank you, Jessica. Now, can I ask you about matters in relation to the minimum wage and something called the accommodation offset, which I think it would be useful if you would really explain to our viewers what that's about.
Yes, of course. So as I mentioned at the beginning, one of the key pitfalls, issues, errors that employers make is regarding minimum wage. So previously, minimum wage requirements didn't necessarily apply. You didn't have to pay minimum wage in these kind of circumstances where you have a service occupancy, a private employee. That's now changed. You now do have to pay minimum wage. So although you have to pay minimum wage, rather confusingly, there's something called the accommodation offset. Now, the accommodation offset applies when you have an employee in a service occupancy. So the accommodation offset is an amount calculated by the government. It updates every year, and it can be deducted from the employee's salary. You don't actually take that money away, but it's deducted hypothetically from their salary depending on how much the accommodation costs them. So service occupancies, employers can charge for rent, bills, and other kind of charges that they may have against the property that they want their employee to pay for, or they may allow the employee to stay in the property completely free of charge. Either way is fine, but minimum wage will vary depending on what the arrangements are. So it is very situation specific. So currently from April 2024, the accommodation offset amount is £69.93. What that means...
Is that per week or per month?
Per week, yes.
Per week.
So what that means, and kind of by way of an example, say you have an employee called David. Now, David works 20 hours a week at minimum wage, £11.44. But David receives his property the accommodation. He's entitled to live in that property for 7 days of the week. Now, you take the accommodation offset at the full amount, £69.93, and you deduct that from his weekly wage, and then the employer can pay the rest. So whilst David is not technically receiving minimum wage, because of that accommodation offset, he is receiving it, because there are certain contractual benefits that count towards salary, and now accommodation is one of them. But if the employer charges the employee for their accommodation, for example, say if they charge rent at £69.93, it has no impact on the salary, and the employee should receive full minimum wage with no deductions. If the employer is charging the employee more than the £69.93 per week, which is quite common, then you work out the difference, and the employee is likely to then receive more than minimum wage because they are paying that additional rent. Essentially, the higher the charges for the property, the lower the salary, the lower the minimum wage is. So the employee then needs to be compensated for the fact that they are paying towards that property.
Okay, so let's take an example, or your example with David. So David, as you said, works 20 hours a week. Let's say that his employer pays him more than the minimum wage, because that's the minimum, and he pays him £12 an hour. So that would be, if my maths is correct, £240 a week. Under the first example, if the accommodation offset is £69.93, that gets offset against the £240, and then the employer is liable to pay the difference.
Yes.
In the second example, if the accommodation that is charged for is, say, £80, for example, then what gets offset against the minimum, or the pay that is paid to David?
Sure. So this is where it gets complicated. So you take the £69.93 because there is accommodation.
Yep.
So you take that amount and you deduct from that what David is paying. In this case, it's actually going to be a negative amount, so it's 20-something pounds. You then add that to his minimum wage, because that is now what he should be owed. So in essence, he's receiving more because he's paying more than the accommodation offset allows.
Got it. Thank you very much indeed. Now, something that always comes up that we have to deal with as employment lawyers is what happens when the employer of the domestic employee, let's say a groundskeeper or a gardener or a domestic home help or a carer, what happens when that employer dies? What happens to the employment then? And when might it continue?
Okay, so there are kind of two routes really, and it really depends on kind of what the executors want to do. So in the first situation, employer passes away, the executors no longer need that employee to remain in place. So in that situation, the employee would technically be made redundant because the role is no longer there for them, or the place of work is no longer there for them. They would be made redundant. If they had a service occupancy, that would trigger the end of the contract would trigger the end of the service occupancy, and they would be paid their redundancy payment, and off they go. As you mentioned, there are circumstances where perhaps employees need to be kept on. So their employment will transfer to the executors of the estate. So their employment will be executors of the estate of whoever has passed away. But the thing to consider with that is that the executors need to make a decision relatively quickly about whether they're keeping on the employee or not, because a break in contract or kind of stopping their employment could potentially render that contract ended. So they need to make that decision relatively quickly. Now, there are circumstances where employees will need to be kept on. For example, if the estate is being sold, perhaps they have groundskeepers, perhaps they have housekeepers that they'll need to keep up with that until the estate is sold. In those circumstances, it continues as normal. So they are employed by the executors, continues as normal. And then when the property sells or when their employment is no longer required, again, there is a redundancy type situation. Service occupancy triggers the end of that, and off they go again. So nothing really needs to be done. Of course, you can update the contract to change the employer's details and to change their duties may change. Hours of work may change. So you may need to be looking at updating the contract and obviously talking to the employees about that. But in theory, not too much to change, and their rights, etc., will continue.
Okay, so above all, really, the executors shouldn't really be too concerned about the employee of the trustee or the deceased's employee, because that employment can continue if they want it, if they're trying to sell the property, for example.
Absolutely, it can continue. They just need to make sure they don't forget about the employee, because they don't go away just because their employer has died. So they can't forget about them and not pay them or anything like that.
Okay, thank you very much indeed for explaining that complex subject. So if you'd like to have any further information from us, or you'd like help, you're an executor, for example, that's responsible for winding up of a loved one's estate, and there's an employee or employees who are employed, used to be employed by that person, then do come and find some advice from us. Do seek us out, and we can give you some advice on all of those issues, from service occupancies to employment. Thank you very much indeed for watching, and see you on the next occasion.